I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for these lessons on state public record laws and the Federal Freedom of Information Act. This is the fourth round of lessons that all build on one another. First, we discussed the law itself, what it covers and how it can be used. Then, we invited a local journalist to share 3 specific requests they made and the stories that resulted. Our previous round of lessons focused on the appeals process, what to do when your request is denied. And now we again have a local journalist to share their experience using the appeals process to obtain records for their reporting. Links to all videos, as well as other valuable information, can be found at nefac.org/FOI guide. This round of lessons is brought to you by NEFAC with support from the Rhode Island Foundation, the SPJ Foundation, MuckRock, SPJ New England, and the New England Society of News Editors. Thank you again for joining us. Now, here's NEFAC's Emily Sweeney to introduce you to your instructor.
Hey everybody, I'm Emily Sweeney from the Boston Globe. I want to thank you all for joining us for this webinar, which is part of our ongoing series on public records laws. This session is going to focus on how a newsroom in Vermont used the public records appeals process to fight for information. And with us is Alan Keays. He's a reporter at the Vermont Digger, where he reports on criminal justice issues. Alan, thank you so much for joining us today.
Thanks for having me. This is a story or a public records request that started with a tip from a reader about a prison superintendent here in Vermont who had been demoted or moved to a position as a probation officer and was receiving roughly the same pay. And the reader was questioning why is that? Why would a person who was the superintendent making close to $100,000 a year be making that much as a probation officer? And so that led us to try to find out why that was. So we submitted a public records request, and the public records request had a lot of very wide-ranging public records requests seeking all the information that led to the decision to move the superintendent at Adams to a probation officer, as well as any complaints that had been lodged against him, as well as how the investigation was handled, and that kind of stuff. And we put in the public records request, and very quickly thereafter, we got a response from the Department of Corrections. And they replied that those documents that we were seeking were not going to be available to us because they cited an exemption to the public records law here in Vermont that exempted records that dealt with personnel matters, particularly dealing with the hiring and the evaluation as well as discipline of an employee. And as a result of that, we had to appeal. And in Vermont, the appeal goes to the head of the department or agency that you're making the request for the records to. So in this case, it was the Department of Corrections. So we had to appeal to the Commissioner of Corrections, which seems a little odd because since we've got denied by them, it seems like it's almost a certainty that you're going to be rejected by them. You're basically saying, can we get the records after you first denied us, and asking the same people. But so we did the appeal and we got denied by this, basically citing the same reason the commissioner cited. These records are exempt because they deal with personnel issues that also deal with the hiring, firing, and disciplining of an employee. So we couldn't get those records. But many years ago, I'd worked at the Rutland Herald, and at the Herald in Rutland, I had been involved in a public records request that we had pursued there that dealt with the Rutland City Police Department. And in Rutland Police Department, the issue dealt with, there were police officers in town who are using their laptop computers working at night. They sometimes park the cruisers out at different spots and they're just kind of like watching traffic. But they had laptop computers in their vehicles, and they were supposedly, we had heard that they were watching pornography on their video, on their cameras, on their laptops. And so we did a public records request regarding that, to find out information. Is this happening? Why is it happening? What action is the police department taking? In that case, we were denied getting those records from the police department. So we went to court in that case, and we able to get a decision by the Supreme Court that said even though the records we were seeking regarding the officers were personnel records, that because we were seeking them not just to find out who they were, we were seeking to find out how the department responded to it, that the court ruled, the Supreme Court in Vermont ruled there had to be a balancing test to determine if the public interest outweighed the private interest. And we argued because we were seeking to find out how the department responded, that the public interest was more important. And as a result, we were able to get the records in that case where the department had cited the exemption dealing with personnel records that wouldn't be available. So in this case, regarding the Department of Corrections here in Vermont, we used that same argument that we had used, that I used in Rutland to get records, that the public interest in finding out why this prison superintendent got removed and got the same peg roughly as a probation officer outweighed his private interest of keeping the records, under wraps in secret from us seeing them, because we wanted to know, how did the department respond to this? Why did this happen? And that was part of our lawsuit. And that was kind of the main thrust of our lawsuit was, hey, the Supreme Court ruled in this Rutland case that those documents should be available if the public interest is stronger than the private interest. And we were certainly arguing that the public interest was strong in this case. And we ended up going to court. The first hearing that we had in the case, the judge said that the Department of Corrections had to at least tell us what documents exist. Before, the department wouldn't even tell us what documents existed. And in Vermont, when they withhold a document from giving it to you, they're to tell us with each document why they're withholding it, the very specific exemption. And so the judge made the Department of Corrections go through each document that existed and cite the exact reason why they weren't giving it to us. And that process went on for a little bit. We ended up finding out that there were like 47 different documents that existed. And we got they call it a Vaughan index, which lists all the documents and the reasons why they were denied. And the department didn't really provide us much information about what documents existed. They just said things like correspondence or letter or a filing just really generic titles for these documents. And so the judge ordered them to go back and be more specific in explaining what the documents were in the exemption. And this went on, like they had to provide 4 different versions of this before they finally got to a point where we could tell roughly what the documents were and whether the exemption applied without seeing the documents. And so we were still arguing and going into court, contending that these documents, these exemptions did not warrant these documents being sealed or kept under wraps. And at that, around that time that we were in the case, had been going on for a few months, there was a change at the head of the Agency of Human Services here in Vermont, which oversees the Department of Corrections. And the new secretary wanted to see some documents become available in the case because the case had been getting some media attention and they were taking some heat for covering up what was going on there at the Department of Corrections. So the new secretary and the Attorney General's office, who was representing the state, agreed to turn over some documents, trying to give us something that they thought would make us go away. And so they provided us with some documents, and one of them was an agreement. It was an agreement that never had become public before, and it laid out the terms about why it was kind of just a standard boilerplate agreement that talked about neither side's admitting wrongdoing. Mr. Adams will be moving to this position of probation officer because of some, quote, allegations, unquote. They didn't say anything more about what the allegations were. So by giving us this one agreement, they thought they were going to, placate us and say, here, we gave you this. This is the agreement. This is what happened. But we decided that based on this agreement, there's actually more information. It made us want to see more about what were these allegations. And so we continued on with the lawsuit. We didn't stop just by getting this agreement. And we continued on. And Michael Smith, who was the secretary of the Agency of Human Services, his argument in releasing some of the records was because he believed that the public interest was starting to outweigh the private interest. Like I said, the case had been getting some media attention. The conditions and how the Department of Corrections was running our prisons had become a big issue in Vermont at that time. So we were able to, like I said, get the agreement, but that spurred us on to try and get more information. And then the union then jumped in and didn't want us to get any information because they didn't want to set a precedent that releasing these records would, it could happen in some other case if they released him in this case. So what happened was Mr. Adams, the superintendent, and the union then filed a motion in the case to block the Agency of Human Services from releasing any more records to us in the case. And there was going to be a hearing that was going to come up in the case where it was going to be the union that was going to be arguing against the state human services agency about the release of the records. So we were bringing the lawsuit. It's a bit of a strange twist because we were bringing the lawsuit seeking the records, but then there was going to be a hearing in our lawsuit where the union and the superintendent were going to be battling it out over who had the right to release the records. And right before that hearing was going to take place, the superintendent said, all right, I've had enough. I don't mind if you release these records, but if you release these records, please include some other stuff in there. And what he wanted included was some of his performance evaluations. And some of those evaluations, said he was doing a satisfactory job in the past, had done a good job in the past. So he wanted those to be part of the record that were released. So the agency then agreed to release more records, as well as provide those records that Adams wanted released that painted him in a more positive light. So when we got the records, we found out that some of the complaints, there was an investigation done into him, an internal investigation, and they were based on complaints that were made about him regarding some crude language that he used, sexist language that he used, inappropriate conduct he had taken part in. And his response to that, to the investigators, were that, first of all, he didn't remember a lot of it. And if he did do anything like that, he said it was going on at other places too. So other prisons in Vermont. So he wasn't unique in how he was acting. So he didn't think it was such that much of a big deal. So we got those records, and a lot of the records that we got were still heavily redacted. Some of the redactions had like full pages that were blacked out and large chunks that were blacked out. So we still wanted to go forward and pursue and find out what was blacked out. So we continued on in the case to try to get more information. And as we were pursuing further, we had a hearing before a judge, and the judge agreed that we should have access to more. They went too far in blocking out the documents, trying to protect identities of whistleblowers and other people who were making complaints. And it didn't give us a full context, according to the judge, of what was taking place. So we were able to get another crack at those documents. What we ended up getting wasn't all that much more when they took out some of the some of the redactions. It didn't tell us all that much more than we knew. I mean, he had been removed from his position and became a probation officer, received roughly the same pay, about $94,000, which is pretty high pay for a probation officer, but is roughly what he was making as superintendent, a little bit less. And we also found out there were allegations made about him regarding his conduct, his language that he used, and how he acted as superintendent. And we ended up having, because we had prevailed in this case, we'd gotten the records. We still didn't find out exactly why he was terminated, or not terminated, but why he was removed and became the superintendent, or why he was removed from the superintendent and became a probation officer. But we did find out some information, and the judge determined that we had substantially prevailed in the case. So as a result, we were able to get our attorney fees in the case, which was about $36,000 that we were able to offset the expenses we had in bringing this case forward. The case went on for 2 years before we were able to totally be at the end of the case. And the taxpayers of Vermont are the ones who ended up having to pay the $36,000 when the records could have been provided to us at the very beginning, 2 years earlier, and it wouldn't have cost the $36,000 to the taxpayers of Vermont. I think this case shows that that previous cases, like the Rutland, when we were trying to get the Rutland Police Department case information about the officers watching pornography, that the Supreme Court decision in that case that set the standard of this balancing test that has to take place regarding the public interest versus the private interest. This was one of the first cases following that kind of used that balancing test. It was based on that balancing test to see, in another example, how these documents can be obtained when a state agency or a public body is claiming that something is a personnel matter. That in Vermont, that's just not, you can't just claim that. You have to show that there's some private interest, like I said earlier, that outweighs the public interest. And by arguing that the public interest was in how the department had carried out the investigation and how they had handled the situation, I think helped show that the public interest was important to find out. And also, as part of this investigation that they had conducted into this prison superintendent, they actually allowed him to see a draft of the results of their investigation, and he was able to kind of edit certain parts of it. And there was one part where a complaint was made against him, and the person who had conducted the investigation determined that the complaint was unsubstantiated, was the term that was used in the draft. And the superintendent didn't like that term, unsubstantiated. So he wanted to say unfounded, because he thought that made it sound like there wasn't even enough evidence to warrant it being unsubstantiated. He thought that unsubstantiated meant that, hey, there's just not enough evidence. It might have happened, but there's just not enough evidence here. But unfounded, he thought, meant that, hey, there's nothing even here. So the person who drafted the investigative report actually made that change in the report. So we're able to find out some things about the case through this public records process that they wanted to shut us down right at the beginning, but we were able to pursue it. And like I said, it took some time, it took some money. We kind of followed it throughout. We wrote stories throughout the process to keep people informed about what was happening, and to kind of document what was taking place in this case. And we ended up, like I said, in Vermont, you can collect your attorney fees in these public records case if you can prove that you substantially prevailed in the case. And in this case, we did substantially prevail. And it actually would typically, it calls for there to be a hearing to determine what those attorney fees are. But in this case, we were able to negotiate with the Attorney General's office a fee rather than go to a hearing. And they agreed to the $36,000 to provide us.
Alan, thank you so much for sharing your story with us and your experience. And yeah, thanks everybody.